A very good morning to Madam Junaida Seno. Today our group, which is Rosere group, is going to present our own presentation about the Contracts Act 1950. A very good morning to Madam. Today, my name is Immanuel Isit Mareia. Today I would like to present about the case that happened between Mr. Smith and Mr. Hugh on 1871. For the facts of the case, Mr. Smith had delivered the first 16 quarter of oats based on what Mr. Hugh ordered. Mr. Hugh had refused to pay the delivered oats and the other remaining order because he thought that it was oats rather than green oats because his racehorses was on diet. Due of Mr. Hugh's action, Mr. Smith had sued him because he breached their contract. Court has ruled that Mr. Smith didn't have to tell to Mr. Hugh about the oats because Mr. Hugh didn't expect there was a possibility of mistakes about the oats. For the issue of the case, the issue is why Mr. Hugh refused to pay the delivered oats and the other remaining order when he made the particular order with Mr. Smith that was based on the initial sample that had been performed by Mr. Smith, and he wants to cancel his agreement with Mr. Smith. According to Section 23 of the Contracts Act 1950 says that a contract cannot be cancelled just because one of the parties involved in the contract made an error in a matter of fact. In conclusion, Mr. Hugh cannot revoke the agreement he has made with Mr. Smith even though he made a mistake on the oath that had been ordered at Mr. Smith. That's all for me. Thank you.
Assalamualaikum Madam, my name is Farhanah Binti Irwan and I will present the case which is the case the Carbolic Small Ball Company. The fact is the Carbolic Small Ball Company made a product called the Smoke Ball and claimed it to be a cure for influenza and a number of diseases. Second, the $100 which means 420 in ringgit Malaysia. Reward will be paid the Carbolic Smoke Ball Company to any person who contracts the increasing epidemic influenza codes or any disease caused by taking codes after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. And lastly, $1,000 equal to RM 4,209 is deposited with the Alliance Bank, Regan Street. And for the issue, whether the advert in question constitute an offer or an invitation to trade. They are made decisions by 3 persons, which is Lord Justice Lindley. Lindley gave the first judgment on it. After running through the facts again, he makes short shrift of the insurance and rigorous contract arguments that were dealt with in the Queen's Bank. Second, like Lindley, Bowen says that the advert was not mere proof because $1,000, which means 4,209 ringgit Malaysia, was deposited in the bank to pay rewards. Third, he said that although an offer was made to the whole world, the contract was not with the whole world. Therefore, it was not an absolute basis for a contract because only the people who used it would bind the company. Fourth, he says that communication is not necessary to accept the term of an offer. Conduct is and should be sufficient. Fifth, good consideration was clearly given by Carly because she went to the inconvenience of using it and the company got the benefits of extra sales. Lastly, decisions by Lord Justice Al Smith. Al Smith's judgments were more general and concurred with both Lindley and Bowen. In the conclusion, this is the most frequently used case in the common law of contract, particularly where unilateral contracts are concerned. It provides an excellent study of the basic principles of contract and how they relate to everyday life. Essential elements of contract including offer and acceptance, consideration, intention to create legal relation. Example were mentioned in this case. This case forms the foundation for contract law. That's all from me. Thank you.
Hello everyone, my name is Frennie. So today I will discuss about the case the Horton Vicious Lane Parking 1971. The fact about this case is Horton drove his car to a car park. Outside the car park, the price was displayed and a notice stated car was parked at your own risk. In small print on the ticket, it was stated to be issued subject to the condition displayed on the premise. On a pillar opposite the machine was a notice stating the owners would not be liable for injuries occurring on their premise. Horton had an incident and sought damage from Shoes Lane Parking. The issue about this case is the Shoes Lane Parking contained the contract was made when Horton received the ticket and parked his car. The ticket amounts to be contractual document which effectively refer to the terms which were clearly visible on the premise. They had taken reasonable steps to bring them to Horton's attention, and they could rely on the exclusion clause and were not liable. For the decision, the exclusion clause had not been successfully incorporated into the contract. Shoes Lane Parking had not done enough to bring the extent of the term to the Thornton's attention prior to the contract formation. The offer was contained within the notice at the entrance, and Horton accepted the offer on those terms when he drove in. It was too late to seek to incorporate further terms after he had driven into the car park. That's all for me. Thank you.
Hello, my name is Norlieda. So next, we will present about the last case, which is Curtis v. Chemical Cleaning and Dyeing Co. 1951. The first one is the fact. The claimant, Curtis, took her wedding dress to be cleaned by a professional laundry service, the defendant, the Chemical Cleaning and Dyeing Company. Upon purchasing their services, the defendant asked the claimant to sign a form, and she asked the service assistant what the consequence of signing would be. The assistant replied that the form merely included exclusion of liability clause for any damage they may cause to any bedding and sequins on garment. However, in actuality, the exclusion of liability clause pertained to all possible damage that may befall a garment whilst being cleaned. When the claimant returned to pick up her dress, it had been damaged by the defendants, and she thus brought claim for damage against them. In response, the defendant submitted that she had no grounds for a claim due to the exclusion of liability clause. For the issue is whether the exclusion of liability clause was binding upon the claimant given that the service assistant had misrepresented its consequence. Based on Section 65 of Contract Act 1950 is when a person whose choice made a contract voidable revokes it. Another party to contract is relieved of any obligation to make any promises contained therein to which he is an offerer. The party that cancels a voidable contract, whether he has gotten any benefits from the contract, he must cancel it, transmit the benefit to the fullest extent to some other parties to such contract that was provided to the person who got it. According to Section 19(1) of the Contract Act 1950, any agreement among individuals can be terminated if consent is acquired by coercion, fraud, and misrepresentation. That's all.
Hello everyone, my name is Karenny. I will present the decision of the Curtis versus Chemical Cleaning and Dyeing Company. According to the case, the Court of Appeal found in favor of the plaintiff, holding that while a party is typically bound by all of the contents of a signed written contract, even if they have not read it carefully, a clause should not be considered legally valid contract, where the drafting party misrepresents the effect of a clause to the other party. As a result, the plaintiff was awarded damage since the responsibility exemption clause was not properly incorporated into the contract. Next, I will explain exclusion clause. What is exclusion clause? An exclusion clause is a statement in a contract that aims to reduce or eliminate one of the parties' liabilities. It may, for example, indicate that if the contract is breached, a party is not liable, or it may seek to limit the variety of remedies available or the time in which they can be sought. Exclusion clauses are found in many different areas of everyday life, from car parks and supermarkets to swimming pool changing rooms and train ticket. Figure 1 is one example of exclusion clause. That's all for me. Thank you.
That's all from us, madam. Thank you. That's all from us, madam. Thank you. That's all